Hello, everyone. Good evening. We'll be reporting about the Securities Regulation Code, Republic Act number 8799. Chapter 1, Section 1. Title: This shall be known as the Securities Regulation Code. Section 2, Declaration of a State Policy. The state shall establish a socially conscious free market that regulates itself, encourage the widest participation of ownership in enterprises, enhance the democratization of wealth, promote the development of the capital market, protect investors, ensure full and fair disclosure about securities, minimize, if not totally eliminate, insider trading and other fraudulent or manipulative devices and practices which create distortion in the free market. To achieve these ends, the Securities Regulation Code is hereby enacted. Definition of terms: securities are shares, participation, or interests in a corporation or in a commercial enterprise or profit-making in venture and evidenced by a certificate, contract, instruments, whether written or electronic in character. It includes, first, shares of stocks, bonds, debentures, notes, evidences of indebtedness, asset-backed securities. Also, it includes investment contracts, certificates of interest or participation in a profit-sharing agreement, certificates of deposit for a future subscription, and fractional undivided interests in oil, gas, or other mineral rights. Also, it includes derivatives like option and warrants, certificates of assignments, certificates of participation, trust certificates, voting trust certificates, or similar instruments, proprietary or non-proprietary membership certificates in corporations, and other instruments as may be in the future be determined by the Commission. An issuer is defined as the originator, maker, obligor, or creator of the security. Also, a broker is a person engaged in the business of buying and selling securities for the account of others. Dealers mean many person who buys, sells securities for his or her own account in the ordinary course of business. And an associated person of a broker or dealer is an employee, therefore, whom directly exercises control of supervisory authority, but does not include a salesman or an agent or a person whose functions are solely clerical or ministerial. A clearing agency is any person who acts as intermediary in making deliveries upon payment effect settlement in securities transactions. And an exchange is an organized marketplace or facility that brings together buyers and sellers and executes trade of securities and or commodities. An insider means first, the issuer, or second, a director or officer of a person controlling the issuer gives or gave him access to material information about the issuer or the security that's not generally available to the public, or it could also be a government employee, director, or officer of an exchange, clearing agency, and or self-regulatory organization who has access to material information about an issuer or a security that is not generally available to the public. Or it can be a person who learns such information by a communication from any foregoing insiders. Pre-need plans, they are those contracts which provide for the performance of future services of or the payment of future monetary considerations at the time actual need, for which plan holders pay in cash or installment at stated prices, with or without interest or insurance coverage, and includes life, pension, education, interment, and other plans which the Commission may, from time of from time to time, approve. A promoter, as defined under the Securities Regulation Code, is a person who, acting alone with others, takes initiative in founding and organizing the business or enterprise of the issuer and receives consideration therefore. Prospectus is the document made by or on behalf of an issuer, underwriter, or dealer to seller or offer securities for sale to the public through registration statement filed with the commission rather. Registration statement is the application for the registration of securities required to be filed with the commission. A salesman is a natural person employed as such as an agent by a dealer, issuer, or broker to buy and sell securities. An uncertified security is a security evidenced by electronic or similar records. An underwriter is a person who guarantees on a firm commitment and or declared best effort basis the distribution and sales of the securities of any kind by another company. Chapter 2, Securities and Exchange Commission, Section 4, Administrative Agency. This code shall be administered by the Securities and Exchange Commission as a collegial body composed of a chairman and 4 commissioners appointed by the president for a term of 7 years each, and who shall serve as such until their successor shall have been appointed and qualified. A commissioner appointed to fill a vacancy occurring prior to the expiration of the term for which his or her predecessor was appointed shall serve only for the unexpired portion of their terms under Presidential Decree number 902-A, unless the context indicates otherwise. The term commissioner includes the chairperson. The commissioner must be a natural-born citizen of the Philippines, at least 40 years of age for the chairperson and at least 35 years of age for the commissioners, of good moral character or unquestionable integrity, of known probity and patriotism, and recognized competence in social and economic disciplines, provided that the majority of the commissioners, including the chairperson, shall be a member of the Philippine Bar. The chairperson is the chief executive officer of the commission. The chairperson shall execute and administer the policies, decisions, orders, and resolutions approved by the commission, and shall have the general executive direction and supervision of the work and operation of the commission and its members, bodies, boards, offices, personnel, and all administrative business. The salary of the chairperson and the commissioner shall be fixed by the President of the Philippines based on the objective classification system and a sum comparable to the members of the Monetary Board in commensurate importance and responsibilities attached to the position. The Commission shall hold meetings at least once a week for the conduct of business or as often as may be necessary upon the call of the chairperson or upon the request of 3 commissioners. The notice of the meeting shall be given to the commissioners, and the presence of the 3 commissioners shall constitute a quorum. In the absence of the chairperson, the most senior commissioner shall act as the presiding officer of the meeting. The commission may, for purposes of efficiency, delegate any of its functions to any department of office of the commission, an individual commissioner or staff member of the commission, except its review or appellate authority and its power to adopt, alter, and supplement any rule or regulation. The commission may review upon its own initiative or upon the petition of any interested party any action of any department or office, individual commissioner or staff member of the commission. Section 5. Powers and functions of the commission. The commission shall act with transparency and shall have the powers and function provided by this code, Presidential Decree number 902-A, the Corporation Code, the Investment Houses Law, the Financing Company Act, and other existing laws. Pursuant thereto, the Commission shall have, among others, the following powers and functions. First, have jurisdiction and supervision over all corporations, partnerships, or associations who are the grantees of primary franchises and or a license or a permit issued by the government. Also, they have the power to formulate policies and recommendations on issues concerning the securities market, advise the Congress and other government agencies on all aspects of the securities market, and propose legislation and amendments thereto. Approve, reject, suspend, revoke, or require amendments to registration statements and registration and licensing applications. To regulate, investigate, or supervise the activities of persons to ensure compliance. To supervise, monitor, suspend, or take over the activities of exchanges, clearing agencies, and other SROs. Impose sanctions for the violation of laws, rules, regulations, and orders, and issued pursuant thereto. Prepare, approve, amend, and repeal rules, regulations, and orders, and issue opinions, and provide guidance on and supervise compliance with such rules, regulations, and orders. Enlist the aid and support of and or deputize any and all enforcement agencies of the government, civil or military, as well as private institution, corporation, firm, association, or person in the implementation of its powers and functions under its code. Issues cease and desist orders to prevent fraud and injury to the investing public. To punish for the contempt of the Commission, both direct and indirect, in accordance with the pertinent provisions of and penalties prescribed by the rules of court. To compel the officers of any registered corporation or association to call meetings of stockholders or members thereof under its supervision. Issues of pena duces tertium and summon witnesses to appear in any proceedings of the Commission and in appropriate cases, order the examination, search, and seizure of all documents, papers, files, and records, tax returns, and books of accounts of any entity or person under investigation as may be necessary for the proper disposition of the cases before it, subject to the provisions of existing laws. To amend or revoke, after proper notice and hearing, the notice or certificate of registration of corporations, partnerships, or association upon any of the grounds provided by law, and to exercise such other powers as may be provided by law, as well as those which may be implied from or which are necessary or incidental to the carrying out of the express powers granted the Commission to achieve the objectives and purposes of these laws. The Commission's jurisdiction over all cases enumerated under Section 5 of PD number 902-A is hereby transferred to the courts of general jurisdiction or the appropriate regional trial court, provided that the Supreme Court in the exercise of its authority may designate the RTC branches that shall exercise jurisdiction over the cases. The Commission shall retain jurisdiction over pending cases involving intra-corporate disputes submitted for final resolution, which should be resolved within 1 year from the enactment of this code. The Commission shall retain jurisdiction over pending suspension of payment rehabilitation cases filed as of June 30, 2005, until finally disposed. Section 6. Indemnification and responsibilities of commissioners. The Commission shall indemnify each commissioner and other officials of the Commission, including personnel performing supervision and examination functions, for all costs and expenses reasonably incurred by such persons in connection with any civil or criminal actions, suits, or proceedings to be liable for gross negligence or misconduct. In the event of settlement or compromise, indemnification shall be provided only in connection with such matters covered by the settlement as to which the Commission is advised by external counsel that the persons to be indemnified did not commit any gross negligence or misconduct. The costs and expenses incurred in defending the aforementioned action, suit, or proceeding may be paid by the Commission in advance of the final disposition of such action, suit, or proceeding upon receipt of an undertaking by or on behalf of the Commissioner, officer, or employee to repay the amount advanced should it ultimately be determined by the Commission that he or she is not entitled to be indemnified as provided in the subsection. The commissioners, officers, and employees of the commission who willfully violate this code or who are guilty of negligence, abuse, or acts of malfeasance, or fail to exercise extraordinary diligence in the performance of their duties, shall be liable for any loss or injury suffered by the Commission or other institutions, such as a result of such violation, negligence, abuse, or malfeasance, or failure to exercise extraordinary diligence. Similar responsibility shall apply to the commissioners, officers, and employees of the commission for one, the disclosure of any information, discussion, or resolution of the commission or confidential or of a confidential nature or about the confidential operations of the Commission unless the disclosure is in connection with the performance of official functions with the Commission or prior authorization of the Commissioners, or the use of such information for personal gain or to the detriment of the government, the Commission, or third parties. Provided, however, that any data or information required to be submitted to the President and or Congress or its appropriate committee or to be published under the provisions of this code shall not be considered confidential. Section 7. Reorganization. To achieve the goals of this code consistent with the civil service laws, the Commission is hereby authorized to provide for its reorganization to streamline its structure and operations, upgrade its human resource component, and enable it to more efficiently and effectively perform its functions and exercise its power under this code. All positions of the commissions shall be governed by the compensation and position classification system and qualification standards approved by the commission based on comprehensive job analysis and audit of actual duties and personal responsibilities. The commission plan shall be comparable with the prevailing compensation plan in the Bangko Sentral ng Pilipinas and other government financial institutions and shall be subject to periodic review by the Commission no more than once every 2 years without prejudice to a yearly merit review or increases based on productivity and efficiency. The Commission shall therefore be exempt from laws, rules, and regulations on compensation, position, classification, and qualification standards. The Commission shall, however, endeavor to make its system conform as closely as possible with the principles under the Compensation and Position Classification Act of 1989. Thank you.
Good evening. I am tasked to report about Chapter 3, or the registration of securities, Section 8 of which provides for the requirements of registration of securities. Securities shall not be sold or offered for sale or distribution within the Philippines without a registration a statement duly filed with and approved by the Commission. The Commission here refers to the Commission, Securities and Exchange Commission, or also known as the SEC. The Commission may first conditionally approve that registration, second, specify the terms and conditions which written communication shall be deemed not to constitute an offer for sale, enter a record of registration, and audit financial statements, assets, and other information of firms applying for the registration. Now, Section 9 provides for the exempt securities. Under this provision, the Securities Regulations Code provides for the requirements of registration, which does, as a general rule, not apply to the following classes of securities. We have here first is that security is issued or guaranteed by the government. Second is that issued or guaranteed by the government of any country with which the Philippines maintains diplomatic relations. Third, those issued by a receiver or by a trustee in bankruptcy. Fourth one, under supervision and regulation of first, the Office of the Insurance Commission, second, the Housing and Land Use Rule Regulatory Board or the Bureau of Internal Revenue. The last one is any security issued by bank except its own shares of stocks. Now, Section 10 provides for the exempt transactions. The requirement of registration in the preceding provision shall not apply to the sale of security of any of the following. The first one is at any judicial sale by an executor, administrator, or guardian, receiver, or trustee in insolvency or bankruptcy. Second is by or for account of a pledge holder or a mortgagee or any of the pledge lien holders selling of offering for sale or delivery in the ordinary course of business and not for the purpose of avoiding the provisions of this code to liquidate a bona fide debt, a security pledged in good faith as security for such debt. The third one is an isolated transaction. The fourth one is the distribution by a corporation actively engaged in business, authorized by its articles of incorporation of securities to its stockholders or other security holders as a stock dividend or other distribution out of surplus. The fifth one is the sale of capital stock of a corporation to its own stockholders exclusively, where no commission or other remuneration is paid. The next one is the issuance of bonds or notes secured by mortgage upon the real estate or tangible personal property when the entire mortgage are sold to a single purchaser at a single sale. The next one is the issue and delivery of any security in exchange for any other security of the same issuer through a right of conversion. The next is a broker's transaction executed upon customers or orders on any registered exchange or other trading markets. Next, subscriptions for shares of the capital stocks of a corporation, note, prior to the incorporation thereof, or in pursuance of an increase in its authorized capital stocks. Next is the exchange of securities by the issuer with the existing security holders exclusively, where no commission or other remuneration is paid or given. The next is the sale of securities by an issuer to fewer than 20 persons in the Philippines during any 12-month period. The last is the sale of securities to any number of qualified buyers. Take note, please, that any person applying for an exemption under this portion shall file with the Securities and Exchange Commission a notice which identifies the exemption relied, which forms and such time as the SEC by the rule may prescribe, and with such notice, and shall pay to the Commission a fee equivalent to 1 over 10 of 1% of the maximum value, aggregate price, or issued value of the securities. Section 12 provides for the procedure of registration of securities. All securities required to be registered shall be registered through the filing by the issuer in the main office of the SEC of a sworn registration statement with respect to such securities, and it also includes any prospectus of such matter. The Commission may reject, refuse registration, or revoke the effectivity of registration statement and the registration of security thereunder after the due notice and hearing, provided that the issuer first has been judicially declared insolvent, violated the provisions of the law, engages in fraudulent transactions, has made any false or misleading representations, failed to comply with any requirements set forth by law. The next one is on its face, incomplete or inaccurate or filing of untrue statements. The next and the last is conviction by competent judicial or administrative body upon a plea of guilty offense involving moral turpitude. Take note that the term competent judicial or administrative body refers shall include a foreign court or competent jurisdiction provided for under the rules of court. The next is the amendment to registration. So if it's on its face incomplete or inaccurate in any material respect, so the SEC may order the amendment. The last provision that I'll discuss is suspension of registration. So the information contained in the registration statement filed is or has become misleading, incorrect, inadequate, or incomplete, or there is fraud. Only when these cases are present, then the suspension of registration is warranted. So the Commission may also suspend the right to sell and offer for such sale of security pending further investigation. So that will be all. Thank you and good evening.
Good evening, everyone. I am Edgar Requilme, and tonight I will be discussing Securities Regulation Code under Republic Act 8799. Basically, I will be discussing Section 4, Administrative Agency, Section 5, Powers and Functions of the Commission, and Section 6, which is the Indemnification and Responsibilities of Commissioners. Administrative Agency, which I will be discussing the composition of the commission, qualifications of commissioners, role of the chairperson, salary, meetings, delegation, and power to review. So first is the composition of the commission. Section 4, it provides that the commission shall be composed of a chairperson and 4 commissioners appointed by the president for a term of 7 years each, and who shall serve as such until their successor shall have been appointed and qualified. So if in case there is a filling of vacancy, the commissioner shall serve only for the unexpired portion of their terms under Presidential Decree number 902A. And in this section also, the term commissioner includes the chairperson. What are the qualifications of commissioners? So first, a commissioner must be a natural-born citizen of the Philippines. Second, at least 40 years of age for the chairperson and at least 35 years of age for the commissioners. And another requirement, which is a good moral character or unquestionable integrity of known probity and patriotism and recognized competence in social and economic disciplines. And lastly, the law also provide that majority of commissioners, including chairperson, shall be members of the Philippine Bar. The role of the chairperson. First, he or she is the chief executive officer of the commission. Second, he or she shall execute and administer the policies, decisions, orders, and resolutions approved by the Commission. And lastly, he or she shall have the general executive direction and supervision of the work and operation of the Commission and its members, bodies, boards, offices, personnel, and all of its administrative businesses. So moving on to the salary, meetings, delegation, and power to review. First, the law provides that the salary of the commissioner shall be fixed by the President of the Philippines based on the objective of classification system at the sum comparable to members of the Monetary Board and commensurate importance and responsibilities attached to the position. For meetings, the meeting shall be held at least once a week for the conduct of businesses or as often as may be necessary upon the call of the chairperson or upon the request of 3 commissioners. For delegation, no, as a general rule, the commission may delegate any of its functions to any department or of office of the commission, an individual commissioner or staff member of the commission. However, it cannot delegate its review or appellate authority and its power to adopt, alter, and supplement the rule or regulation. And lastly, its power to review. The Commission may review upon its own initiative or upon the petition of any interested party any action that will arise, of any department or office, individual commissioner, or staff member of the Commission. Section 5 provides for the powers and function of the Commission. So here we talk about powers and functions and also the jurisdiction of the Commission. Screen, there are 14 enumerated powers and functions of the Commission. First is to have jurisdiction and supervision over all corporations, partnership or associations Who are the grantees of primary franchises and or license or permit issued by the government? Second, formulate policies and recommendations in issues concerning securities market, advise Congress and other government agencies in all aspects of security market, and propose legislation and amendments thereto. Third, approve, reject, suspend, revoke, or require amendments to registration statements and registration and licensing applications. Fourth, regulate, investigate, or supervise the activities of persons to ensure compliance. Fifth, supervise, monitor, suspend, or take over the activities, exchanges, clearing agencies, and other SROs. Sixth, impose sanction for the violation of laws and rules and regulations and orders and issued pursuant thereto. Seventh, prepare, approve, amend, or repeal rules, regulation, and orders and issue opinions and provide guidance on. Eighth, enlist the aid and support and or deputize any of all enforcement agencies of the government, civil or military, as well as any private institution, corporation, firm, association, or person's implementation of its powers and function under its code. Ninth, issue cease and desist orders to prevent fraud or injury to the investing public. 10th, punish the contempt of the Commission, both direct and indirect, in accordance with the pertinent provisions and penalties prescribed by the rules of court. 11, compel the officers of any registered corporations or association to call meetings of stockholders or members thereof under its supervision. 12, issue subpoena jurisdictum and summon witnesses to appear in any proceedings of the Commission, and in appropriate cases order the examination, search, and seizure of all documents, papers, files, and records, tax returns, and books of accounts or any entity or person under investigation, as may be necessary for the proper disposition of the cases before it, subject to provisions of existing laws. 13th, suspend or revoke after proper notice and hearing the franchise of certificate of registration of corporations, partnership, or association upon any grounds provided by law. And 14th, exercise such powers as may be provided by law, as well as those which may be implied from or which necessary to or incidental to carrying out of the express powers granted the Commission to achieve the objectives and purposes of these laws. Under Section 5 of the Securities Regulation Code, it also provides the Commission's jurisdiction. So the Commission's jurisdiction over all cases enumerated under Section 5 of Presidential Decree Number 902A is hereby transferred to the Courts of General Jurisdiction or the appropriate regional trial court branches that shall exercise jurisdiction over the cases. The Commission shall retain jurisdiction over pending cases involving intra-corporate disputes submitted for final resolution, which should be resolved within 1 year from the enactment of this code. And lastly, the Commission shall retain jurisdiction over pending suspension of payment rehabilitation cases filed as of June 30, 2000 until finally disposed. Section 6, or the indemnification and responsibilities of commissioners. Here in the indemnification, the Commission shall indemnify each commissioner and other officials of the Commission for all costs and expenses reasonably incurred by such persons in connection with any civil or criminal actions, suits, or proceedings to be liable for gross negligence or misconduct. However, in cases when there is settlement or compromise, indemnification shall be provided only in connection with such matters covered by settlement as to which the Commission is advised by external counsel that the persons to be indemnified did not commit any gross negligence or misconduct. Roles and responsibilities of the Commission. The Commissioners, officers, and employees of the Commission who willfully violate this code or who are guilty of negligence, abuse, or acts of malfeasance or fail to exercise extraordinary diligence in the performance of their duties shall be held liable for loss or injury suffered by the Commission or other institutions such as a result of such violation, negligence, abuse, or malfeasance, or failure to exercise extraordinary diligence.
To continue with our report on Securities Regulation Code, or the SRC, I am going to discuss Section 7, which is the reorganization, and Section 8, which is the requirement of registration of securities. Section 7, Reorganization. To achieve the goal of the Securities Regulation Code consistent with the civil service laws, the Commission is hereby authorized to: first, is to provide for its reorganization; second, is to streamline its structure and operations; and third, is to upgrade its human resource component and enable it to more efficiently and effectively perform its functions and exercise its power under the Securities Regulation Code. All positions of the commissions shall be governed by a compensation and position classification system and qualification standards approved by the commission based on comprehensive job analysis and audit of actual duties and personal responsibilities. The compensation plan shall be comparable with the prevailing compensation plan in the BSP or the Bangko Sentral ng Pilipinas and other government financial institutions, and shall be subject to periodic review by the Commission no more than once every 2 years without prejudice to yearly merit review or increases based on productivity and efficiency. The Commission shall therefore be exempt from first, laws; second, rules and regulations on compensation, position classification, and qualification standards. However, the Commission shall endeavor to make its system conform as closely as possible with the principles under the Compensation and Position Classification Act of 1989 or the Republic Act 6758 as amended. Chapter 3. Chapter 3 is the registration of securities. Section 8 talks about the prescribed requirement of registration of securities. Securities shall not be sold or offered for sale or distribution within the Philippines without a registration statement duly filed with and approved by the Commission. And prior to such sale, information on the securities in such form and with such substance as the Commission may prescribe shall be made available to each prospective purchaser. The Commission may have the following authorities. First, the Commission may conditionally approve the registration statement under such terms as it may deem necessary. Second, is the Commission may specify the terms and conditions under which any written communication, including any summary prospectus, shall be deemed not to constitute an offer for sale. And third, is that the Commission may audit the financial statements, assets, and other information of the firm applying for registration of its securities whenever it deems the same necessary to ensure full disclosure or to protect the interest of the investors and the public in general. Record of the registration. A record of the registration of securities shall be kept in registered securities, in which shall be recorded orders entered by the Commission with respect such securities. Such register and all documents or information with respect to the securities registered therein shall be open to public inspection at reasonable hours on business days.
And now let us take a look at the related jurisprudence as regards to fraudulent transactions. So this is GR number 197032, July 26, 2017, Securities and Exchange Commission versus Price Richardson Corporation, Consuelo Velarde Albert, and Gordon Resnick. The facts of the case: Price Richardson Corporation, respondent herein, is a Philippine corporation duly incorporated under Philippine laws. Its primary purpose is to provide administrative services, which includes, but is not limited to, furnishing all necessary and incidental clerical, bookkeeping, mailing, and billing services. Its former employee, sometime in October 2011, Michelle Avelino, executed a sworn affidavit alleging that Price Richardson was engaged in boiler room operations, wherein the company sells non-existent stocks to investors using high-pressure sales tactics. Whenever this activity was discovered, the company would close and emerge under a new company name. Janet Cirillo corroborated Avelino's claims. She was a former employee of Capital International Consultants Incorporated, a corporation that allegedly merged with Price Richardson. She claimed that their calls to prospective investors should be in Price Richardson's name. The Regional Trial Court then issued 3 search warrants against Capital International and Price Richardson and seized Price Richardson's office equipment and documents. Consequently, the Securities and Exchange Commission filed before the Department of Justice its complaint against Price Richardson, the incorporators and directors. The SEC alleged that Price Richardson was neither licensed nor registered to engage in the business of buying and selling securities within the Philippines or act as a salesman or an associated person of any broker or dealer. As shown by the seized documents and equipment, Price Richardson engaged in seeking clients for the buying and selling of securities, thereby violating Section 26.3 and 28 of the Securities Regulation Code. In addition, Respondent Price Richardson insists that the provision of Section 28 of the Securities and Regulation Code prohibits anyone from engaging in the business of buying and selling securities without registration from the Securities and Exchange Commission if those transactions are offered to the public within the Philippines. Does not apply in this case because the alleged buyers of the securities were not citizens of or resided in the Philippines. Additionally, the allegedly sold or offered securities were registered outside the Philippines, where the alleged sales are also transpired. Hence, the sales are not under the Philippine jurisdiction. The State Prosecutor Reyes issued a resolution dismissing the Securities and Exchange Commission's complaint for lack of probable cause. The SEC filed before the DOJ a petition for review of State Prosecutor Reyes' resolutions. This was denied by Department of Justice Secretary Gonzales. Then SEC filed a petition for certiorari resolutions. The CA affirmed the assailed resolutions. Hence, the SEC filed a petition for review before the Supreme Court against Price Richardson, Velarde Albert, and Resnick. Issue: whether there is probable cause to indict respondents for violations of Sections 26.3 and 28 of the Securities Regulation Code. Ruling: yes, petitioner provided sufficient basis to form a belief that a crime was possibly committed by Respondent Price Richardson. The complaint alleged that respondents committed violations of the following Securities Regulation Code, Section 26, fraudulent transactions. It shall be unlawful for any person, directly or indirectly, in connection with the purchase or sale or any securities, to Section 26.3, engaged in any act, transaction, practice, or course of business which operates, would operate as fraud or deceit upon any person. Section 28, registration of brokers, dealers, salesmen, and associated persons. 28.1, no person shall engage in the business of buying or selling securities in the Philippines as a broker or dealer, or act as a salesman or an associated person of any broker or dealer unless registered as such with the Commission. Petitioner further supports its charges by submitting the complaint affidavits and letters of individuals who transacted with Price Richardson. The SEC has submitted the complaint of Mr. Don Sectos Nalanta, a citizen of Sri Lanka who clearly named Price Richardson as selling him 1,000 shares of Yugo International Telecom Incorporated sometime in April 2001. At such time, and until today, Price Richardson was not authorized to act as traders or brokers of securities in the Philippines. Furthermore, the Supreme Court added, if this honorable court were to consider the setup of Price Richardson, it was as if it engaged in outsourced operations wherein persons located in the Philippines called up persons located in foreign locations to inform them of certain securities available in certain locations and to determine if they wanted to buy these securities which are offered in a different country. The evidence gathered by petitioner in the statement of respondent Price Richardson are facts sufficient enough to support a reasonable belief that respondent is probably guilty of the offense charged. And now let's us go to another related jurisprudence on insider trading. So this is the case of Securities and Exchange Commission versus Interport Resources Corporation et al., GR number 135808, October 6, 2008. So the facts of the case: on August 6, 1994, the Board of Directors of Interport Resources Corporation approved a Memorandum of Agreement with Ganda Holdings Berhad. Under the Memorandum of Agreement, IRC acquired 100% or the entire capital stock of Ganda Energy Holdings Incorporated, which would own and operate a 102 megawatt gas turbine power generating barge. The agreement also stipulates that GE would assume a 5-year power purchase contract with National Power Corporation. It was also agreed that IRC will issue to GHB 55% of the expanded capital stock of IRC amounting to 40.88 billion shares, which had a total par value of 488.44 million. IRC would acquire 67% of the entire capital stock of Philippine Racing Club Incorporated. PRCI owns 25.724 hectares of real estate property in Makati. Under the agreement, GHB, a member of the Westmont Group of Companies in Malaysia, shall extend or arrange a loan required to pay for the proposed acquisition by IRC of PRCI. IRC alleged that on August 1994, a press release announcing the approval of the agreement was sent through facsimile transmission to the Philippine Stock Exchange and the SEC, but that the facsimile machine of the SEC could not receive it. Upon the advice of the SEC, the IRC sent the press release on the morning of August 9. The SEC averred that it received reports that IRC failed to make timely public disclosures of its negotiations with GHB and that some of its directors, respondents herein, heavily traded IRC shares utilizing this material insider information. On August 16, 1994, the SEC chairman issued a directive requiring IRC to submit to the SEC a copy of its aforesaid Memorandum of Agreement with GHB. The SEC chairman further directed all principal officers of IRC to appear at a hearing before the Brokers and Exchanges Department of the SEC to explain IRC's failure to immediately disclose the information as required by the rules on disclosure of material facts. In compliance with the SEC chairman's directive, the IRC sent a letter dated August 16, 1994 to the SEC, attaching thereto copies of the Memorandum of Agreement. On September 19, 1994, the SEC chairman issued an order finding that IRC violated the rules on disclosure of material facts. In connection with the Old Securities Act of 1936, when it failed to make timely disclosure of its negotiations with GHB. In addition, the SEC pronounced that some of the officers and directors of IRC entered into transactions involving IRC shares in violation of Section 30 in relation to Section 36 of the Revised Securities Act. Respondents filed a motion for reconsideration before the SEC but was denied. They elevated their case before the CA. The Court of Appeals granted their motion and issued a writ of preliminary injunction which effectively enjoined the SEC from filing any criminal, civil, or administrative case against the respondents herein. The SEC filed a motion for reconsideration which the Court of Appeals denied in a resolution issued on September 30, 1998. Hence, this petition before the Court. Issue: whether the Court of Appeals made an evident mistake when it ruled that no civil, criminal, or administrative actions can possibly be had against the respondents in connection with Sections 30 and 36. Ruling: yes, the Court of Appeals made an evident mistake when it ruled that no civil, criminal, or administrative actions can possibly be had against the respondents in connection with Sections 30 and 36. This Court does not discern any vagueness or ambiguity in Sections 30 and 36 of the Revised Securities Act, such that the acts prescribed and or required would not be understood by a person of ordinary intelligence. Section 30 of the Revised Securities Act reads, "Insider's duty to disclose when trading. It shall be unlawful for an insider to sell or buy a security of the issuer if he knows a fact of special significance with respect to the issuer or the security that is not generally available, unless the insider proves that the fact is generally available or if the other party to the transaction or his agent is identified. The insider proves that the other party knows it or that the other party in fact knows it from the insider or otherwise." Letter B. Insider means the issuer, a director or officer of a person controlled by or under common control with the issuer. Person whose relationship or former relationship to the issuer gives or gave him access to a fact of special significance about the issuer or the security that is not generally available. Or 4. A person who learns such a fact from any of the foregoing insiders as defined in this subsection with knowledge that the person from whom he learns the fact is such an insider. C. A fact is of special significance if, in addition to being material, it would be likely, on being made generally available, to affect the market price of a security to a significant extent, or B. A reasonable person would consider it especially important under the circumstances in determining his course of action in the light of such factors as the degree of its specificity, the extent of its difference from information generally available previously, and its nature and reliability. Letter D. This section shall apply to an insider as defined in subsection B3 hereof only to the extent that he knows of a fact of special significance by virtue of his being an insider. The provision explains in simple terms that the insider's misuse of non-public and undisclosed information is the gravamen of illegal conduct. The intent of the law is the protection of investors against fraud committed when an insider using secret information takes advantage of an informed investor. Insiders are obligated to disclose material information to the other party or abstain from trading the shares of his corporation. This duty to disclose or abstain is based on two factors. First, the existence of a relationship giving access directly or indirectly to the information intended to be available only for a corporate purpose and not for the personal benefit of anyone. And second, the inherent unfairness involved when a party takes advantage of such information knowing it is unavailable to those with whom he is dealing. In the United States, the obligation to disclose or abstain has been traditionally imposed on corporate insiders, particularly officers, directors, or controlling stockholders, but that definition has since been expanded. The term insiders now includes persons whose relationship or former relationship to the issuer gives or gave them access to a fact of special significance about the issuer or the security that is not generally available, and one who learns such a fact from an insider knowing that the person from whom he learns the fact is such an insider. Insiders have the duty to disclose material facts which are known to them by virtue of their position, but which are not known to persons with whom they deal with and which, if known, would affect their investment judgment. In some cases, however, there may be valid corporate reasons for the non-disclosure of material information. Where such reason exists, an issuer's decision not to make any public disclosures is not ordinarily considered as a violation of insider trading. At the same time, the undisclosed information should not be improperly used for non-corporate purposes, particularly to disadvantage other persons with whom an insider might transact, and therefore the insider must abstain from entering into transactions involving such securities. Under the law, what is required to be disclosed is a fact of special significance which may be a material fact which would likely, on being made generally available, to affect the market price of a security to a significant extent, or b. one which a reasonable person would consider specially important in determining his course of action with regard to the shares of stock. It is important to note that Section 30 of the Revised Securities Act allows the insider the defense that in a transaction of securities where the insider is in possession of facts of special significance, such information is generally available to the public. However, respondents failed to allege that the negotiations of their agreement with GHB were made known to the public through any form of media for there to be a proper appreciation of the issue presented. As regards Section 36 of the Revised Securities Act, it imposes upon one a beneficial owner of more than 10% of any class or any equity security, or two, a director or any officer of the issuer of such security, the obligation to submit a statement indicating his or her ownership of the issuer's securities and such changes in his or her ownership thereof. The said provision reads: Sections 30 and 36 of the Revised Securities Act were enacted to promote full disclosure in the securities market and prevent unscrupulous individuals who by their positions obtain non-public information from taking advantage of an uninformed public. No individual would invest in a market which can be manipulated by a limited number of corporate insiders. Such reaction would stifle, if not stunt, the growth of the securities market. To avert the occurrence of such an event, Section 30 of the Revised Securities Act prevented the unfair use of non-public information in securities transactions, while Section 36 allowed the SEC to monitor the transactions entered into by the corporate officers and directors as regards the securities of their companies. The broad language of the anti-fraud provisions, which included provisions on insider trading, should not be circumscribed by fine distinctions and rigid classifications. The ambit of anti-fraud provisions is necessarily broad so as to embrace the infinite variety of deceptive conduct. Hence, the court granted SEC's petition, reversed CA's decision, and lifted the injunction that is issued. Thank you and good evening.
Good evening, classmates. In order to gauge your learnings towards Republic Act 8799, here are some problems for you to answer. So, problem number 1. X corporation is engaged in a scheme whereby an investor is required to become a business center owner, or BCO, who must fill up and sign its application form. The terms and conditions printed at the back of the application indicates that the BCO shall mean an independent representative of Power Homes, who is enrolled in the company's referral program and who will ultimately purchase real property from any accredited real estate developers, and as such is entitled to as a referral bonus or commission. So paragraph 5 of the same indicates that there exists no employer-employee relationship between the BCO and the Power Homes Unlimited Corporation. So the BCO is required to pay $234 as his enrollment fee, and his enrollment fee entitles him to recruit two investors who should pay 234 US dollars each, and out of which amount he shall receive 92 US dollars. So in case the two referrals or enrollees would recruit a minimum of 4 persons, each recruiting 2 persons who become his or her own downlines, the BCO will receive a total amount of 147.20 US dollars after deducting the amount of 36.80 US dollars as property fund from the gross amount of 184 US dollars. After recruiting 128 persons in a period of 8 months for each left and right business groups, or a total of 256 enrollees, whether directly referred by the BCO or through his own lines, the BCO receives a total amount of 11,412.80 US dollars after deducting the amount of 363.20 US dollars as property fund from the gross amount of 11,776 US dollars, as now an accumulated amount of 2,700 US dollars, constituting as his property fund placed in a property fund account with the China Bank. So this accumulated amount of 2,700 US dollars is used as partial or full down payment for the real property chosen by the BCO from any of the accredited real estate developers. So the question is X corporation involved in the distribution of securities. So what do you think is the answer? So the answer for the question is yes. X corporation is engaged in the business of distributing securities in the form of investment contract. So to be a security subject to regulation by the Securities and Exchange Commission, an investment contract must be proved to be an investment of money in a common enterprise with expectation of profits and primarily from efforts of others. So in this case, what BCO is really acquiring is the possibility of deriving the money from the sale of the plans. Once an individual has purchased a plan, he turns his effort towards bringing others into the organization, for which he will receive a part of what they pay, and his task is to bring prospective purchase to adventure meetings. So the answer to the question was from the case of Power Homes Unlimited Corporation versus Securities and Exchange Commission, GR number 1641842, February 26, 2008. So the second problem or exercise is this. T Corporation has a business plan under which it will assign leasehold rights over the lots and condotel units for a valuable consideration, and the assignees will enroll said units under a management contract with T Corporation or its authorized condotel operator to undertake the leasing of the same, wherein profits will be realized unremitted to the assignee on top of the guaranteed aggregate 30-day use per year of the condotel unit. So the question is, does the scheme involve investment contracts? So the answer to the question is yes. The transaction are investment contracts that are securities under the SRC. So what is involved in a scheme whereby a person invests his money in a common enterprise and is led to expect profits primarily through the efforts of others. So T Corporation is offering more than leasehold rights, but also the opportunity to contribute money and to share in the profits of leasing condotel units managed and currently owned by T Corporation. So the third question is Union Times Incorporation has a total assets of 60 million pesos with 210 stockholders holding at least 100 shares each. The company has two principal stockholders, ABC, which owns 60% of the shares of stock, and XYZ, which owns 17%. ABC in turn is owned to the extent of 21.31% by Acme Corporation, 29.69% by Golden Boy Corporation, 9% by XYZ, and the rest by the individual stockholders. So none of the parties is a publicly listed company. XYZ now proposes to buy Acme's and Golden Boy shares in ABC, which would give it direct control of ABC and indirect control of Union Mines. Is the proposed acquisition by XYZ subject to the mandatory tender offer rule? Why or why not? What is a tender offer and when it is mandatory? So, yes, the proposed acquisition by XYZ is subject to mandatory tender offer rule. So with 210 shareholders holding at least 100 shares each, Union Mines is a public company, although not listed in the company. So acquisition of shares in Union Mines is therefore subject to the tender offer rules. So SRC Rule 19 provides that there is a mandatory tender offer if at least 35% of the outstanding shares of a public company is to be acquired in one transaction or a series of transactions during a 12-month period, or even if any of the acquisition is less than 35% threshold, but the result thereof is the ownership of more than 51% of the total outstanding shares of a public company. So if XYZ will acquire the shares of Acme Corporation, Golden Boy Corporation, in Union Mines and such shares are added to the existing shares of XYZ in Union Mines, then XYZ will own more than 51% of the outstanding capital stock in the Union Mines, and it should be noted that the rules apply even if one will acquire the shares in the corporation that owns the shares of a public company including a subsidiary. So, next question. Uh, Andante Realty, a marketing company that promotes and facilitates sales of real property through leverage marketing, solicits investors who are required to be a business center owner by paying an enrollment fee of $250. So the BCO is then entitled to recruit two other investors who pay $250 each. So this is the similar case with the first case I presented earlier. So the BCO receives $90 from the $250 paid by each of his recruits and is credited to a certain amount for payments made by investors through initial efforts of his business center. Once the accumulated amount reaches $5,000, the same is used as down payment for the real property chosen by the BCO. And the question for this is, does this multi-level marketing scheme constitute an investment contract under the Securities Regulation Code? So define investment contract. So yes, the multi-level marketing constitutes an investment contract. So under the Securities Regulation Code, an investment contract is a contract, transaction, or scheme which involves an investment of money, common enterprise. So it was also stated in the first case, the definition of investment contract, and with expectation of profits and primarily from the efforts of others, which is indicated in the Powerhouse and Limited Corporation versus Securities and Exchange Commission. So that was the end of my report. Thank you so much and good evening.